the Rancho Palos Verdes Planning Commission meeting on October 28th, 2025. Can I get a pledge of allegiance, please?
Ready to begin.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Have a roll call, please.
Yes, Commissioner Kristen.
Here.
Commissioner Chura.
Here.
Commissioner George.
Here.
Commissioner O'Connor.
Here.
Commissioner Santa Rosa.
Here.
Vice Chair Brock is absent. And Chair Noman.
Here.
Okay.
Next, we'll go to communication. Is there any city council items?
No city council items.
Oh, sorry, I skipped the agenda.
yeah.
Approval of the agenda. Any motion to approve?
Make a motion to approve.
A second? All right. If there's no objections, agenda is approved. We'll move on to communication. Any city council items?
No city council items and no staff items.
All right. Any communication from commission? Okay, thank you. We'll move on to comments from the audience.
We have nobody to speak from the audience.
Okay. Moving on to the consent calendar.
I'll move to approve.
Okay. Is there a second?
I'll second.
Thank you. Do we get a roll call for that? Or, okay, I'm going to abstain from it because I was absent last week.
Okay.
As I was. I missed that. Are you taking a roll call or not?
Okay.
Okay.
Next, we'll move on to continued public hearings. There are none. And next is new public hearings.
Yes, the first item is for general plan amendments related to the landslide. And this is a public hearing, and we do have a staff presentation.
Great. Please.
Okay. Okay. Good evening, Chair and Commissioners. This agenda item is for the Planning Commission to consider recommending general plan amendments to the City Council to update the status of the landslide and references to the new Chapter 15.20 of the Rancho Palos Verdes Municipal Code. On August 19th, the City Council adopted ordinance number 692, which repealed Chapter 15.20 of the Rancho Palos Verdes Municipal Code and replaced it with a new Chapter 15.20. This revision was to address the changed circumstances in the Greater Portuguese Bend landslide complex, permanently prohibiting new residential construction in the landslide area. The ordinance does allow property owners to replace, restore, and repair development within its existing footprint. At the time of these amendments, staff identified cross-references to 15.20 and other municipal code sections to determine that there are revisions that were needed to align those code sections with the new code language. In doing so, when adopting ordinance number 692, the City Council also updated the references to 15.20 in sections 1504 and 1640 of the municipal code. As well, there were references in the zoning code to 15.20 that needed updating. Those amendments required the Planning Commission review in an advisory capacity, and the City Council had referred those to the Planning Commission. As you may recall, the Commission considered those amendments at your September 23rd meeting. In reviewing the proposed zoning code amendments for consistency with the general plan for that September 23rd consideration, the staff also identified cross-references to Chapter 15.20 in the general plan that needed attention. The general plan still references the prior title of Chapter 15.20, and the land movement information in the general plan is only as current as 2018. So these inconsistencies and proposed revisions were provided as Exhibit A to the resolution for consideration tonight. These inconsistencies and proposed revisions, just to summarize, we're looking at in the acronyms and abbreviations section of the general plan would be a cleaning that up to match the general plan document. Under the conservation open space element would be correcting the reference to the building moratorium, Portuguese Bend landslide, and to adopt the title of Greater Portuguese Bend Landslide Complex. So it's really just tidying up the language in the reference to 15.20. It also, in the conservation open space element, we're looking to provide the updated date of the active movement, and then also adding a new figure with the map of the Greater Portuguese Bend Landslide Complex. In the land use element, it's similarly correcting the reference to the 15.20, no longer calling it a building moratorium or the Portuguese Bend landslide, but rather recognizing it as the Greater Portuguese Bend Landslide Complex, as it's now referred to in 15.20. Removing older references to moratorium regulations, and then providing an update of the landslide emergency since 2013 and the adoption of the new landslide regulations. So this is the area with the biggest change to provide that update in the status to the land movement. And under the safety element, it would be, again, correcting the references to 15.20 in the language, removing language to referring to it as the building moratorium or Portuguese Bend landslide, and then providing an updated date of the active movement, and again, adding a new figure with the map of the Greater Portuguese Bend Landslide Complex. So staff recommends that the Planning Commission adopt the resolution before you tonight, recommending to the City Council the proposed amendments to the general plan elements to update the status of the landslide conditions and references associated with the adopted amendments to the Rancho Palos Verdes Municipal Code, Chapter 15.20, entitled the Greater Portuguese Bend Landslide Complex Regulations on Land Use Permits, approved with adoption of ordinance number 692. And that concludes my presentation. It's pretty brief, but if you do want to go through any of the changes, I can pull that document up.
Thank you. Any questions for staff?
Yeah, I just have one question, which is the new map that's being drawn, how is it represented? And I'll tell you the reason I ask is because we've had maps in the past that have been drawn with Sharpies. And when you zoom in, you find that the line is 20 feet long. So is the map today drawn via parcels or via GPS? And are there parcels that are partially in and partially out of the zone?
Yeah, the map it's done through our GIS system. It is following the recommendation of the city's geologist and the observed movement and changes. That was adopted, and there are some parcels where it is overlapping a portion of it, where it might overlap a portion of that parcel. It's not an all in or all out. It would just be that those regulations will apply to only the portion of the site where the landslide area is on the site.
I see, and that's a very fine line, right, in a GIS
Yes.
system?
Yes.
Okay. Okay, thank you.
Yep.
How many parcels are being affected?
That's a good question.
Approximately.
I have that.
Size of the parcels?
There are the size of the parcels vary greatly. We have several parcels that are city-owned. If you can hold a minute, I just pulled this up with my with the GIS consultant, and so I want to pull that information for you. Okay. Let me, you can just hold a minute. I truly just got the numbers from him about a week ago.
Well, the report referenced somewhere around 430, and a number of that was within the area.
Oh, did we have that in the, okay,
Yeah,
got it.
But it wasn't, and the size of the lots, because there was a.
Yeah, the size of the lots aren't there because they vary. I mean,
Are they
they're,
all over an acre?
no, I don't think, no, because there are lots in Seaview. So the Seaview lots would not be over an acre, but there are some that are significantly over an acre in
And
size.
so those, Commissioner Christian brought this up a time or two ago about limiting property rights. And there is a way of still proceeding with building if there is a process for an owner of a property.
Yes,
Correct?
correct.
And that's spelled out already, of course?
Yes, there are multiple different procedures that they could go. If they have something already developed, they can proceed with replacing, repairing, restoring that particular
Within the
structure.
foundation system.
Within the same footprint. If they needed to revise the footings or foundation system so that it protects the structure, they can do that as well. But they have to do it within the what would be approved by the building official.
Sure. And what about lots under an acre? They were talking, the code sections that were in this report referenced developments having to exceed 1 acre, or at least 1 acre, so that it had the most minimum size of footprint. Or am I reading that wrong?
Yeah, for what you're reviewing tonight, it's just the general plan amendments that
Of
are
course.
related to that.
This is a housekeeping
Yes.
language exercise.
Yeah,
But there is an opportunity to ask you questions of what the intentions of this is.
right. It's, there's nothing that would preclude an applicant, a property owner to apply for different projects, or if they wanted to, and there are some exceptions to accessory structures and such that they could do, as far as those properties that if somebody feels that they don't, that shouldn't apply to their property, that their property hasn't moved, they can apply for an exception so that they could be, or excuse me, an exclusion so they could be excluded from the landslide area. But there are different proofs that they would have to go through to do that.
Within Seaview, that's like 60 lots, correct? Or less?
It's less than 60.
There's a table. Most of it's in Portuguese Bend.
Yes.
And those lots are all acre parcels? Some, most?
In Portuguese Bend, they're probably larger than acre parcels. Yeah.
All right. Currently, how many lots are undeveloped in the Portuguese Bend areas?
Right.
Ballpark.
And that's where I wanted to pull up the
Fair enough.
information.
And the reason why I'm asking this is that how does this all affect the housing element as well?
Right.
Because if essentially you're making these properties very difficult or impossible to build on.
The Department of Housing and Community Development is aware of our ordinance. They're reviewing that. And that's procedurally what we do is we submit that to them so they're aware of it. We've met with the HCD representatives so they have the information. They understand the severity of the situation with the land movement that has occurred here. So we're not looking at a significant, because there's no net loss that's proposed with this, because a property owner could replace, repair, restore on what they have. That's no net loss is one of the state regulations that they would be looking for. So we have confirmed that with them, that there would be the capability of them replacing, repairing, and restoring their structures. So, yeah. So HCD is aware, and they recognize the significance and concern of construction in this area with the active land movement.
Okay, thank you.
You know, if I may follow up on my brother in here, now that he's breached this topic. At the time the state of emergency went into effect, I think there was 10 builders' remedies whose clocks were stopped because of that. Now, their clocks started again on November 6th, I guess, when the state of emergency went away. And I don't believe the moratorium has any impact on stopping any builders' remedies that were in effect before the state of emergency. I think there were 10 builders' remedies in the bean field and 9 properties, maybe 6 or 7 properties with 10 applications. I assume those are either going to time out or someone's going to submit an application within 180 days.
Right, and I know our city attorney's office, and that's not on our discussion for tonight as far as that item. So I don't want to go too far astray of what our topics, our agenda item is.
Fair enough.
Right. That being said, certainly they'd have to go through whatever that process was. I know some of them had timed out before the moratorium went into place in 2023, and the others, it's going to be that same circumstance. So that time clock would definitely be reinstituted.
Yeah, it's just something to watch because he's brought up is if there's building going on, there is actually could be a net gain should someone decide to build, and they can. Right. And I'm actually glad to hear that there's some sort of exclusion thing. I didn't realize that because the real issue that I think wasn't addressed by the city council was we approved a number of projects in that area just before the state of emergency went into effect. Those people quietly and waited while the state of emergency went away, and they were met with a moratorium that prevented them from building forever. So the folks who really have been impacted are the folks who work very hard and with us in the Planning Commission a number of times to get approved plans, and then those approved plans are now no longer possible. And that could have been I don't know that that's on the list of exclusions. I doubt it is, but that was my opinion. It never quite got through. So I think those are the folks that were impacted by this and had no relief. Thank you.
Mm-hmm.
Are there undeveloped lots within the complex?
Yes.
And to my fellow commissioner's point, what relief are those people given in this regard?
They do have a process for applying for an exclusion to have their property excluded from the landslide.
And is there a fee for them to do that?
Yes.
Okay. I think you know how I'm going to continue after that.
You think it'd GoFundMe? You think they should go to GoFundMe?
Any other questions for staff? Yes.
So this map of the greater land, is that area as large as it's ever been?
It's actually reduced in size in some areas, and it's slightly increased. So there were, I believe it was 8 properties, 7 or 8 additional properties. That was a portion of those in the Seaview area. But there was an area that was off of Sea Cove that was in there, and that the geologist determined is not part of the Greater Portuguese Bend landslide complex. So it's not related to this landslide, and those were removed.
So it's about the same size as it's always been?
It's approximately, yes. Mm-hmm.
We have had these cleanups coming before this commission multiple times. Is this the last cleanup of language, or will this become a bi-monthly thing?
For this particular item, or related to the landslide, or just in general?
So we have had multiple meetings where this is the main agenda topic of cleaning up language to these resolutions, to the code, to these ordinances. Are we going to, are these going to be on the agenda for the next 6 months, or is this the end of it?
This is it for the landslide, those that are related to the revisions to the chapter 15.20. That being said, if there's any change to zoning, for example, we may have more with wireless as we see the need to, then the new wireless regulations went into place last year, we may see that there are some adjustments that need to be made to that. In that case, those have to come to the Planning Commission for you in an advisory capacity to provide the recommendation to determine that it's in compliance with the general plan. So you're going to see additional zoning changes come before you. I can't tell you how many you're going to have, but I can tell you wireless will be coming before you within the next few months.
You know, I think the only one that might be relevant is where the language means something, is the state of California still does not consider landslides to be, you know, remember Governor Newsom did veto our bill to make a landslide. But before that, there was discussion about what do we name this thing that gives us the ability to get state funding? And my take was, let's name it anything it takes to make it applicable to state funding. If we have to call it, you know, I don't know what, but landslide appeared to be the wrong name. And so if there's a name change coming, I hope that it's tied to our ability to get funding. That would be that. Otherwise, changing the name to, I guess, getting the word Portuguese Bend out of making it complex means it fits Klondike Canyon and all the other places. So I got that. So I'm okay. I'm okay with the cleaning up the language. I think this particular one makes sense. My only caveat is picking a name that's tied to something the state will fund.
I have another question regarding the land movement. So prior to the current emergency, development was allowed in this area. Is that correct?
Development was allowed in the area. That was a requirement to make an amendment to 1520. It was a court order for the city to have to make that amendment to allow that.
To allow it or to ban it?
To allow it, the court required that the city had to take action in the Monk's lawsuit. And as a result, the city had to allow for development in the area.
Which what was voted by the council is a banning on all development, other than a replacement of existing structure with existing foundation and perhaps ancillary buildings.
It's a restriction on new development, yes.
So,
but it does reverse the Monk's decision in the areas where Monk's was applicable, correct?
Yes, there were 16 properties in the Monk's lawsuit. Of those, 12 were developed. Of the 12 that were developed, 5 have been red or yellow tagged. So this is significant, and the change in circumstances is what has moved the city council to make these changes in the
But I'm
15.20.
saying it still has reversed that decision in that area, and the change it would require no lawsuit.
It has changed, we have changed the 15.20, yes.
So what is the remedy, or is a property owner have to appeal this through this commission, the staff, the council, when the current emergency hopefully is reduced? As you allowed, or we allowed development in this area, and it's been moving for the last 70 years, give or take. Now we're saying you can't ever build there on your vacant land, period. That's what this says. Tell me if I'm wrong. A moratorium, to me, is no. So if I have a bare lot next to my house, and I'm allowed to do something on my house in this area, and the land is reduced in movement, and, you know, obviously it's been horrible, but it's reduced in movement, the person that owns that bare lot now has to go back and fight to use their land. That's basically what my interpretation of this is.
Mr. Chairman, if I may, I'm becoming very, very confused. I thought the item before us was the general plan, which is just an articulation of goals and objectives. It is not code. The code itself was before this commission, I believe, at our last meeting. So are we talking about the code that has already been passed and we're still venting issues about something that we can no longer deal with? Or are we talking about the general plan that is before us?
If I may, on that point, and that's a good one, the revisions to 15.20 were not before the Planning Commission. It was the references to 15.20, making sure that the title was, and that's similar to what we have before us tonight with the general plan amendments. 15.20 is outside of the jurisdiction or the realm of the Planning Commission's review and advisory capacity. That's under the building code. So that did not, the 15.20 itself did not, and that is not
Thank you for that
consideration.
clarification.
Yeah.
Right.
And just one last maybe question or clarification. So the general plan is a dynamic document that continues to be updated as needed. And so the way that it's being updated now for the current state of the landslide zone, it can be updated again in the future if conditions change. Is that correct?
Absolutely, as can the municipal code.
Okay.
Yeah.
I think what's our opportunity right now is to kind of address some of the ongoing concerns that you had the other night. And I still think that's fine. Again, I think we've all recognized that this is just a housekeeping issue for the language change, but this is our chance to have a dialogue and ask some questions as to where we might want to go with this in the future. There's some different thoughts amongst us.
Just want to be clear, though, that 15.20 is not under the realm of you making recommendations or advice.
Completely
Yeah,
understood.
got it.
Just
Okay.
within this,
And right now
just within the zoning.
we're asking staff for clarity
Exactly.
on questions. It's not our discussion. It's not,
Yeah.
we still haven't had open the public hearing for people to talk.
Absolutely.
Questions? All right. I will move to open the public hearing. Is there any speakers tonight?
We do not have any speakers in the audience or signed up to speak online.
Okay, thank you. We'll close the public hearing and we'll move into discussion. Is there any discussion?
I'm willing to make a motion to adopt staff recommendation.
I'll second.
Okay. Any amendments to the motion or comments on the motion?
Well, I have a comment, and I know that other members of I don't know anything. The commission may feel I'm being stubborn or something on this, but I do not like overly broad swath type of decisions, and I feel like in this case, I believe the council has made a mistake. I do not support it, and I will not vote yes to fix the language on something that I would not support in the first place. And it was brought up 2 meetings ago why you voted no, Commissioner Kristen. And I didn't articulate that as well as I could have. But basically, if I'm not just going to change the wordings of something that I don't agree with. Because if I don't agree with the original premise or the total, there's no amendment that suits me. In this case, I think it's overly broad, and therefore I will not be voting yes on our adoption of the language. And I really don't want to talk about that anymore. You can challenge me, I won't be saying much, but.
Well, in fact, what I'd like to say is that I agree. I think if I run the council, I probably would have fought this moratorium. I don't think it was terribly warranted, to be quite frank. But I do agree this isn't the forum for that. And I won't quibble with the language, even though I agree.
And I understand that this is purely housekeeping. We have no power here. You're bringing this before us as a requirement for advisory. Not even advisory, I think. So every commissioner can vote as they want, and that's fine. But the underlying issue makes me go the other way.
Thank you. Any other comments? All right, we'll move into voting.
Okay. Commissioner Kristen,
Nope.
Commissioner Chura,
Yes.
Commissioner George,
Yes.
Commissioner O'Connor,
Yes.
Commissioner Santa Rosa,
Yes.
Vice Chair Brock is absent, and Chair Nolman.
Yes.
Okay, that passes. That's the end of that item.
All right, thank you. We'll move on to next item, which is continued business. Appears there is none. And we'll move on to new business.
Yes, for this item, I think that the name is a little misleading. It's really to address the sewer easement vacation. It's not reviewing the actual site plan for this project. With that, I'm going to turn it over to Senior Planner Jessica Bobbitt, who's available online.
Thank you. Just one moment, getting my video up and running. Okay, thank you. Okay. Good evening, Chair and members of the Planning Commission. An item you have before you this evening, as Brandy outlined, is for a finding of consistency with the Rancho Palos Verdes general plan for the vacation of our sewer easement located at 5801 Crest Ridge Drive. To provide some background, on February 6, 1979, the City Council approved a conditional use permit number 41 and variance number 34 to allow for the construction of the Canterbury Retirement Facility, which is comprised of 4 buildings and ancillary site improvements. On June 14th, 2024, the applicant applied to a revision to the conditional use permit for an approximately 24,000 square foot addition and ancillary site improvements. On September 30th, 2025, the City Public Works Department received a request letter and exhibits from the applicant to vacate a portion of the sewer easement as there was proposed improvements over this area and the easement was no longer in use. On October 21st, 2025, the City Council initiated proceedings for the vacation of the sewer easement. Pictured here is the project site that's shown with the star outlined in red and yellow. The project site is a 5.2 acre lot located within an institutional zoning designation. It is currently improved with the retirement community called the Canterbury. To the east and west of the subject site are institutional uses. A residential tract is located on the south side of Crest Ridge Road. And on the north side of the project are residential units that are located within the Rolling Hills Estates city boundary. This slide here shows the proposed sewer easement to be vacated, which is outlined in red. And next we have the general plan consistency findings, which were initiated by City Council on October 21st, 2025. This requires the Planning Commission to consider 3 criteria with respect to the determination of consistency with the general plan, which include location, purpose, and extent. In terms of location, the site is located within an institutional zoning designation, and the sewer easement proposed to be vacated is not in the location, or excuse me, is located within the western portion of the site. Staff believes that the objectives and policies of the general plan will still be consistent with the abandonment with the sewer easement proposed to be abandoned. The purpose of the sewer easement was originally to provide sanitary sewer to the initial development, which was constructed in 1980. However, at an unknown time thereafter, a portion of the sanitary sewer within the easement was abandoned and relocated. No records were found showing the corresponding sewer easement was properly vacated, and however, the sewer easement is no longer in use for city sewer purposes. As for extent, the existing site is serviced by Los Angeles County sewer lines off of Crest Ridge Road, running from south to north and west to east along the property. The sewer easement proposed to be vacated is located within the western center portion of the property. Staff believes the extent of the easement vacation is consistent with the affirmation goals and policies of the general plan. Following the Planning Commission's evaluation for the general plan consistency, other utilities will be notified and findings will be eventually presented to the City Council for consideration to vacate the easement at a future duly noticed public hearing. Following the conclusion of the easement vacation process and the completeness review of the requested application, the proposed CUP revision will be scheduled for Planning Commission consideration. Staff recommends that the Planning Commission adopt the resolution finding the city's vacation of the sewer easement on 5801 Crest Ridge Road is consistent with the city's general plan and determine the sewer easement vacation is exempt from the California Environmental Quality Act requirements. This concludes staff's presentation. Planning staff and I believe public works staff are available for any questions. Thank you.
Any questions for staff?
I have one, perhaps, of City Council. So as we commented earlier, the general plan typically expresses goals, objectives, desires, things of that sort. And at least in my mind, I didn't think it had any power of any particular code, et cetera. But in this circumstance, it seems that the government code, and we're a general city, so I can understand that, actually claws into its governance the general plan, which I thought was kind of an odd construct. So the question I have is basically twofold. Are there other parts of the government code that clause into determinations, et cetera, our general plan? So it has the force of being tantamount to a building code or a planning code or whatever you might be? Or is this the only case where government code pulls in the general plan. Because it seems like that whatever we stipulate in the general plan, the government code can bring back to us, say, but you said you would be a semi-rural type of community, but you're not doing that anymore, notwithstanding whatever SB said. So I'm trying to understand what, in the order of import, who has precedence over what?
Yes, and maybe our city attorney may be able
Yeah, I know,
to.
he's puzzling and smiling. I can see it from here.
Yes, I elaborate a little bit more.
The government code does reference the general plan in different sections, but in terms of where else, I don't have an answer to that question at this moment. That would require a little bit deeper dive into the government code
At
itself.
least to satisfy some commissioner, that might help, because it just seems a very odd construct. Again, the general plan, I know we're required to update whatever number of years, et cetera, but that it actually has the full force and effect of law by virtue of something in the government code that said, yeah, but you actually have to do that. So it would be a helpful understanding, because in this section here, you destroyed what I thought the first section was all about, which apparently is not true in some circumstances. So anyway, so that's the part that I find odd, one. And two, again, the order of findings, the city actually made the determination that this can be vacated in accordance with our general plan and is exempt from CEQA. So if Big Brother's already done it, why does the little brother have to come in afterwards? I don't quite understand that ordering.
Yeah, this is actually a requirement of our own resolution as a city. So it's not as you could see, this is not a public hearing. It's not something that requires anything more than bringing this to the Planning Commission. And that's the requirement. So we're fulfilling that requirement of our own procedure that we adopted.
Is there any particular history tidbit of that particular, I find it, the reasoning, I'm perplexed. And I'm just kind of curious if there's an anecdote that this is how it came about, this is why we tap our heads and rub our bellies.
Yeah, I don't know, because it was 1990.
Again, just curious, okay.
Yeah, so I don't have that history as to why they did that, but I'm sure it was just, instead of the city council just making a decision, it's something on private property, let's have the Planning Commission weigh in, provide some feedback, and
then I take it in the order of this idea that if we should unanimously say no, it has no effect because whatever city council decided is still binding.
I think the city council would probably similar to when it is a public hearing and does have a more strict process, but per law, the city council will make findings as to why they would go against that, yeah.
Okay, well, an interesting Rube Goldberg. I was kind of curious of how whoever designed this came about, but so those were my questions. Thank you, Chair.
Yeah.
Thank you. Any other questions?
As you know, in years past, the city council has solicited the advice of the Planning Commission prior to making decisions, which was an interesting and meaningful work for 7 people who currently do nothing.
Yeah. Reasoning applied well has always been fascinating to me, but I'm even more fascinated when reasoning gets kind of twisted upside down and backwards.
How many times have we sat here and make recommendations for something that's already passed?
Yes. Well, that's why I said that's.
And my take is because the city council did not solicit our input. And it's their privilege to do so or not do so.
Anyway, so enough of process. But again, I enjoy the slight comedies of life. Thank you.
Any other questions for staff before we move on?
I have a question.
Yeah.
So, is this something that the Canterbury or the owner of the land or the lessor came to the city about, or is this something the city just, hey, we've got this easement, it's easier to clean up? How does?
Yeah, they came to the city, so the city has, they have an application that they submitted to the city. You are going to see that before you once this is vacated and it can be deemed complete and move forward. And but they have some improvements on this easement that's no longer in use. And so it was something that the Public Works Department had to evaluate to confirm that, yes, this isn't being utilized. It's not something we need to have utilized because they rerouted the sewer line. So there is another easement on the property where the sewer is actually located. So this isn't necessary for the purposes of Public Works needs for the easement. So it came about because of the application from the Canterbury, and it is something that they had to request the vacation of the easement.
Okay, thank you. And is there, since this is new business, does it still go before the public? Do I open?
It's not a public hearing, so you wouldn't need to open a
Okay.
public hearing, and we don't have anybody signed up to speak.
Thank you. So I'll move into discussion. Is there any discussion?
I don't have any issue with this. I mean, apparently there's an adequate easement for sewage in this area that's existed since before my kids were born, and they're in their 20s. And given that there's no apparent necessity for it, and there's an adequate replacement in process, I wouldn't bust the Canterbury on this one. Who, if we vote no, that they're the only victims, right? Because, so I don't see an issue with it.
No, it's just getting them the opportunity to develop the land that they want to develop. Just gets it out of the way.
I'd like to make a motion to adopt the resolution as noted.
I will second that.
Any comments or amendments to it? All right. Can I get a roll call, please?
Yes, Commissioner Christian,
Yes?
Commissioner Chura,
Yes.
Commissioner George,
Yes.
Commissioner O'Connor,
Yes.
Commissioner Santa Rosa,
Yes.
Vice Chair Brock is absent, and Chair Nolman.
Yes.
That passes.
Great, thank you. Okay, next is items to be placed on future agendas.
For the pre-agenda, just so you're aware, for November 11th, that is a holiday, and we will cancel that meeting. And then for the November 25th meeting, we do have an agenda item. We have that twice annually where we go through the work plan and accomplishments so that we can report that back to the City Council, and that'll be on the November 25th meeting. Do be aware that that is the week of Thanksgiving. So we will have that meeting. So if you're not able to attend, please notify myself and Chair Nolman for that. And then we have, I know that the pre-agenda items for December 9th only has one height variation, but we are actually going to have a second height variation application before you at that meeting.
Great, thank you.
And then for the second meeting in December, again, since that's at a time when during the holidays, that meeting will be canceled as well.
Okay,
I believe that's the 22nd? 23rd, okay. Yeah.
all right, thank you. Any last comments? Get a motion to?
No, but it's an interesting question at this point in the meeting.
You never know. All right, can I get a motion to adjourn?
I'd make a motion to adjourn.
I second that.
All right, thank you. Meeting is adjourned.